Coming to you from our digital desk, we're about to take you to a sentencing in Geauga County, and really just a devastating set of circumstances. The man you see sitting at the defendant table closest to us there with the coat and tie, that is the defendant here, Jason Slepsky. He has already pleaded guilty to being drunk when he crashed into an ambulance. Now, that set off a series of events. That crash actually killed the patient who was in the back of the ambulance, 47-year-old William Malley Jr. It also severely injured the paramedic who was in the back with Malley Jr. She was Jessie Sopko. She had to be life-flighted to a local hospital because of the severity of her injuries the paramedic's injuries. And again, has pleaded guilty, and today is sentencing day for Jason Slepsky. The trooper said that Slepsky crashed his Jeep into the ambulance, causing the ambulance to roll several times. That's how bad this accident was. And again, he is accused and pleaded guilty now to being drunk at the time of that crash. You can see a number of family and supporters in the back. We do expect to hear from at least two individuals to speak in this. Not sure if that will be the paramedic themselves or if they will both be from the family of William Malley Jr. Remember, he was just 47 years old in the back of that ambulance when Jason Slepsky smashed into it, causing that ambulance to flip and roll several times. That's just how bad this accident was. And again, the patient that was in the back of the ambulance, William Malley Jr., he is of Dorset, Ohio. He was pronounced dead at the scene. And it was the paramedic that was in the back of the ambulance that had injuries so serious, were the level of injuries, had to be taken by medical helicopter to a local hospital where Jessie Sopko is a man, where he had to have several surgeries for his injuries. We're just waiting for the judge to come into the court and give the all rise. As again, Jason Slepsky is about to hear his sentence for injuring. Actually, both of the paramedics, as you might imagine, were injured in that. The driver and the paramedic that was in the back. We will hear the exact counts that he has pleaded guilty to, and again, what kind of a prison sentence he will be facing. Again, just waiting for the judge. This happened back on September 26th of 2023. It was about 2:30 in the morning on Chardon-Windsor Road, and that's in Geauga County. That was from the troopers. Slepsky was originally indicted on charges of aggravated vehicular homicide, aggravated vehicular assault, and OVI, operating a vehicle under the influence. And again, this was at 12:30 in the morning. He crashed his Jeep into that ambulance, causing it to roll several times. And again, just the bizarre set of circumstances. That ambulance was transporting a patient. That patient then dies as a result of this crash. That was William Malley Jr., just 47 years old at the time. The paramedic, Jessie Sopko, he is 25, 25, that was in the back with that patient. Again, his injuries were so severe, it took a helicopter to get him, they used a helicopter to get him to the hospital, and then several injuries for that crash. Again, just waiting on the judge here for the all rise. A very quiet courtroom, and we get the all rise. So let's take you to Geauga County Court of Common Pleas for today's sentencing.
It's Monday, April 14th, 2025. I'm Judge Paschke. We're on the record on case number 23C-156, matter known as State of Ohio versus Jason A. Slepsky. Mr. Slepsky is present in the courtroom today. He's represented by his attorney, Catherine Meehan, Mr. Flays, the Geauga County Prosecutor, as well as Assistant Geauga County Prosecutor Mr. Burling, are present on behalf of the state of Ohio. And we have Mr. Zupancic with us via video from the court's probation offices. Mr. Flays, will you introduce the case, please?
Thank you, Your Honor. The defendant was indicted by the Geauga County Grand Jury in an indictment filed on December 18th, 2023. Charges were aggravated vehicular homicide, felony of the second degree, 2 counts of aggravated vehicular assault, felonies of the third degree, and then 2 counts of OVI, misdemeanors in the first degree, and a count of failure to stop at a stop sign, a minor misdemeanor. After much pretrial discovery, motions that were filed, and other legal issues that I'm sure will be discussed later on in this proceeding, the parties did reach a plea agreement, and that plea was, the defendant did change his plea on February 6th of this year, and this matter is set for sentencing. That's what we are here for now. Thank you.
Okay, thank you. Ms. Meehan, do you or your client have any reason why this matter should not proceed to sentencing at this time?
No, Your Honor, thank you.
And have you had an opportunity to review the pre-sentence investigation?
Yes, Your Honor.
And do you have any changes or modifications to the pre-sentence investigation?
No.
All right, then you may present what you have to present regarding sentencing.
Thank you, Your Honor. I know I've also submitted a sentencing memorandum for this court's consideration. Obviously, we're aware that 2 of the charges that my client pled no contest to carry with it the imposition of a prison term. We're seeking through our allocution essentially the mandatory minimum at this time. I think that the court, when looking at the facts of this case and the sentencing factors under 292912, would think that that would be appropriate. I don't suggest that what happened here is insignificant. A person lost their life, 2 other people were injured, and I know that my client is something that he thinks about every single day. The big thing here with this case is a little bit different. The court is aware that there is a Supreme Court case, I think it's actually set for oral argument next week, regarding specific issues with the marijuana metabolite. This isn't a circumstance where we had an individual who was actively using marijuana and then decided to get into his car and then got into an accident. This is a circumstance where a metabolite of the substance was in his system. And what we've learned over the course of these types of cases is that the metabolite doesn't actually have an impairment effect. It is still a per se level that you can't be over, but I think it's a little bit different when you look at it from that perspective, that it's not the same as drinking alcohol and getting in your car and driving impaired. I believe at the time of this incident, my client had indicated to the police that he had used marijuana weeks prior, which would make sense because of the amount of the metabolite that was in his urine. The other things that we learned over the course of the case was that there were no drugs in his blood, which had he been actively using, we would likely see the actual active THC in his blood. So those are the reasons why I think this case is a little bit different. And again, those are arguments that are pending before the Supreme Court currently regarding the proximate cause of an accident where there's a death of an individual with a metabolite, and those arguments are set for argument here this month. But again, so that's why we're asking for the minimum. And I know that the state of Ohio, through our plea agreement, had agreed to ask for concurrent sentences, so sentences to run together. So that's what we're asking the court to consider. Under 292912, when we look at the seriousness and recidivism factors, there's no question that there was serious physical harm here. I did cite some case law within my memorandum, which essentially demonstrates that when the element is of the crime itself, you can't necessarily use that to enhance the seriousness. So I would propose to the court that since serious physical harm is also an element of these vehicular assaults, that doesn't necessarily mean his conduct is more serious than what normally constitutes the offenses. None of the other factors that would make his conduct more serious are applicable in this case. And even when you look at the recidivism factors, the only things that would tend to suggest that he would reoffend is that he does have some prior criminal history. I would submit to the court, though, that he has no juvenile adjudications. He has lived a law-abiding life for a significant period of time. I think that the circumstances here are not likely to recur, and he is absolutely remorseful for what happened here. I know we've talked about this through pretrial litigation, that but for those metabolite results, this is essentially a misdemeanor. And again, I don't say that to diminish the seriousness of what the families went through in this case, because reading all of those letters, seeing the photographs, knowing what the families went through, again, that is significant. My client recognizes that. It's something that he thinks about every single day. This, again, it's not a circumstance where he decided to use illicit substances and then drive his car. This was use that happened weeks prior, and it is a per se level violation, which is why we're before this court. We're just asking the court for consideration. We're asking the court to consider the minimum sentence in this case, and that's what we're asking the court to impose at this time.
Thank you. I will give Mr. Slepsky an opportunity to speak. Ms. Meehan, is there anyone else that the defense plans to call at this time?
Your Honor, this is my client's mother.
Okay, I'm just gonna, if you can come over here to the podium. I know you're relatively close to it.
My name is Elisa Slepsky, it's spelled A-L-E-S-A. My son has been very remorseful, and he does live with this every day, and we do discuss it on a very regular basis. I know there are a lot of people praying for him today and have been praying for him, and the church is definitely trying to help him get through this, and are trying very hard to help him support what happened and how he's going to live with the death in this family. And Mr. Sopko, who got seriously injured in this accident, he has a son. He actually has two sons, one who lives with him and one he spends a great deal of time with, that are in dire need of him to help raise him. So I plead that you give him the minimum sentence and help his family out. I know there's a lot, but he did not get behind that wheel of the car intentionally and hurt anyone. It was an accident, and thank you for your time.
All right. Now, Mr. Slepsky, it's your opportunity to speak. I'm going to ask you to stand up, please.
I would just like to apologize for everything that happened. I do understand the severity of the situation. It was an accident. I do think about it every day, the death of the gentleman and Sopko's injuries and everything that happened during this accident. And my life choices that I've made over the time that have put me in the situation. But I just sincerely just want to apologize and just hope that you do, have some look down upon me in the situation and ask for the minimum sentence, considering the situation of the case. So thank you, Your Honor.
Mr. Flace.
Thank you, Your Honor. The state would ask the widow, Rose Mallon, to come forward to speak first.
My name is Rose Maley, and William Bill Maley was my husband. He was the patient in the ambulance that was killed. I have been without my husband for about 1.5 years now. I sent Bill to the hospital knowing in my heart and in my head that just like other times, he would be fine and home in a few days. That did not happen. He never came home. I lost my husband, my best friend, and so much more. I have lost all of our dreams of moving out here to the country to grow old together. My life is all but over. Everything around me reminds me that our dreams were crushed, that I have to start over alone. So many times something will happen, and I think to myself, I can't wait to tell Bill. But then I realize I'll never be able to do that again. I have a granddaughter and a grandson who lost their pop-up. The pain and the effects of this cannot be measured. This wasn't an elderly grandparent that died. Their pain goes beyond sleepless nights and crying. My granddaughter stopped saying, "I love you" that day. Her response to someone telling her that they loved her was simply to say, okay. She learned that someone you love can be taken away in a heartbeat, and that loving them means it's going to hurt. She withdrew from everyone and tucked all of her emotions away. It has and is been a long road, but she's finally saying, I love you again. My grandson was telling people his pop-up was murdered. I had to explain to him that pop-up was killed, not murdered, and there is a difference. How do you explain that to a child? His response was, but pop-up's still dead. He became angry easily and often. He isn't even a teenager yet and says, remember when Pop-Up and I did this or that? Once those words were followed by, those were the good old days. I'm still losing every day. Bill was our only source of income. We moved to the country, but I've never had a driver's license, which was okay because he drove. I no longer have that transportation, but I have to go back to work. I may have to move back to the city and leave the last bit of our dream to die too. I truly have to start my life completely over. Thank you.
Thank you, Your Honor. And Jesse Sepko is here with his family, friends, co-workers. He's elected not to speak, but I know the court carefully has always read all of the letters submitted and the information that was submitted on behalf of the victims. And very hard for me to put into words, what they were able to put into words, and I know the court will take that into consideration. The defendant's decision that night altered many lives. It ended Bill Bailey's life and, altered many other lives. And a lot of those people are here in the courtroom today. And we've talked about the legal issues. The court's aware of the legal issues, but those really shouldn't be issues for today's sentencing. Certainly the defendant's going to appeal. This particular complex legal issue is, we believe, being argued next week before the Ohio Supreme Court, and so that issue will be decided, and the case may come back here, it may not. Our appellate district has certainly decided that issue in our favor, and that's what the law is in this courtroom. But what is relevant is the defendant drove that night, and he had a prohibited level of marijuana in his system. The law says you can only have so much marijuana in your system, and he exceeded that limit. And when you exceed the limit of a prohibited substance, and you drive and you kill someone, there are serious consequences. He blew through a stop sign, he failed to yield for an ambulance, flipped the ambulance over. The patient, Bill, was killed. Paramedic in the back, Jesse, was almost killed, and in fact, right after this happened, the information I received was that he wasn't going to make it. And the paramedic who was driving the ambulance was also injured. And again, the letters really paint a much better picture than I could do here, so I'm not going to try. But Jesse's got a young wife, a very young child at home, really a heartbreaking situation, and he has spent every day September 26th of 2023, and that's been a long time. Rose has spent every day dealing with the loss, and Jesse has spent every day from then until now and into the future recovering from these horrific injuries, which he still is suffering from. I guess in these cases you always hear accident, this was an accident, and that term's used by a lot of people, and maybe that's a way to characterize this, but it's the state's position the defendant was under the influence that night. That's a pretty, you could call it an accident, but you could also call it, how do you run a stop sign, a two-way stop at an intersection right by your house that you're very familiar with, and fail to see an oncoming ambulance? Probably because you're under the influence.
because according to the law, he was under the influence. He was under the influence of marijuana. And then you look at the defendant's record, and you think, this isn't someone who, well, maybe he smoked marijuana a couple weeks ago, but he was fine, and he's led a law-abiding life. He's been in prison before. He hasn't led a law-abiding life. He's got a prior drug history. He's got a history of violent offenses. He's got a history of thefts. And his traffic record, certainly, I wouldn't characterize. And he drank alcohol that night. He didn't test over, but he did drink alcohol. He was out at a bar, drank alcohol. He had marijuana in the system, too much marijuana in the system. And he has caused this impact on all of these people. And there needs to be severe consequences for that. The law calls for mandatory prison time on counts 2 and 3. And so the state is asking for 5 years or 60 months, I think it's said in the statute, but 5 years on count 1, which is the homicide offense, 5 years on count 2, which is the maximum for Mr. Sopko's horrific injuries and what he's gone through, and then 2 years on count 3. The state would ask that the 5 years or the 60 months on counts 1 and 2 and the 2 years on count 3 be run concurrently with each other, and defendant be ordered to pay costs. And also the South Central Ambulance District has requested restitution in the amount of $20,412.46 for equipment costs that were not covered through insurance. And Jesse's medical bill's been covered through workers' comp, and Rose is going to be making an application with the victims of crime for the funeral expenses. But that at this time is only restitution that the state is requesting. Thank you.
Ms. Meehan, regarding the restitution, do you wish to be heard?
Your Honor, we would oppose restitution in that specific amount. The only thing that I saw to reflect any restitution figure was that letter that was submitted that just had a figure attached to it. I haven't seen any sort of other documentation that supports that that was an actual out-of-pocket expense that wasn't covered by insurance, and that's for that reason we would oppose the imposition of that restitution amount.
All right, the court has reviewed the pre-sentence investigation. I have reviewed all of the letters that have been submitted. I have reviewed the other documents. There was a sentencing memorandum and some other documents that were submitted as well. I have read the plea agreement, and I've listened to the statements that have been made here in court today. I have reviewed the entire record in the case. I've considered the purposes and principles of felony sentencing under Revised Code 2929.11, as well as the seriousness and recidivism factors under Revised Code 2929.12, including the seriousness of Mr. Slepsky's conduct, the factors which make his conduct more serious, as well as the factors which make his conduct less serious. In taking a look at those factors, the factors indicating conduct more serious, I do find that Factor 2 applies in that one of the victims, in that all three of the victims suffered serious physical harm. As far as factors indicating conduct less serious, I don't find that any of those factors apply. As far as factors indicating defendant likely to commit future crimes, I find that Factor 2 applies, and that is that the defendant does have a history of criminal convictions. Factors indicating defendant not likely to commit future crimes, I did hear Mr. Slepsky state that, and I heard his mother state that he does show remorse for the offense, so I do find that that factor applies. All right. Now, in taking all of this into consideration, as Mr. Flay said, the court is required and will look at this matter as, even though there are some legal issues and some things that are out of this court's control that are pending with the Ohio Supreme Court. The court must look at this situation as Mr. Slepsky was legally impaired at the time this this terrible accident happened. I did read all of the letters from the victims. I read the letters from the family members, and I obviously there's no way that nothing that this court can do to fix or change what happened and what has happened to you. I admire all of you for your courage, and I wish you all continued healing, particularly Mr. Sopko, particularly Ms. Maley. I can't imagine what you've all gone through, but your letters did certainly have an impact in reading those things. So I just wanted to acknowledge all of you. Mr. Slepsky, I also heard what you had to say, and I understand that. These situations are a result and a consequence, though, of actions that you took, and now we have to deal with them. So taking all of that into account, as to count one, Mr. Slepsky, I sentence you to a term of 48 months or 4 years in prison. There's also a Class 2 driver's license suspension, which is 3 years to life, and I'm going to impose a 6-year driver's license suspension. Count 2, as to the aggravated vehicular assault, I also sentence you to a term of 48 months in prison. That will be served, that is to be served concurrent with the sentence in count 1. That is a mandatory sentence, and there is a Class 3 driver's license suspension, and I'm going to suspend your driver's license for a period of 6 years. As to count 3, I sentence you to a term of 36 months in prison. That is to be served concurrent with count 1 and count 2. That's also a mandatory sentence. And there is a Class 3 driver's license suspension, which I will impose a driver's license suspension of 6 years. I am going to go over post-release control with you. You may be subject to a term of up to 2 years of post-release control under Revised Code 2967.28. If this period of post-release control is imposed following your release from prison, and if you violate the conditions of that supervision, the parole board may impose a prison term as part of the sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional consecutive prison term of 1 year or what time remains on your post-release control term may be added as an additional penalty. You are also instructed that most prison inmates are eligible to earn days of credit against their prison sentences for participation in programs. Said days of credit, if you're eligible to earn them, are not automatically awarded but must be earned in the manner specified in the statute. I'm going to give you credit for 24 days time served. Counsel, is that correct?
I believe so, Your
I
Honor.
got that from the pre-sentence investigation.
Just check. Yes, Your Honor, 24 days.
Okay. And then I am going to dismiss counts 4, 5, and 6. Is that correct, Mr. Flays?
Yes, Your Honor.
All right. Now we'll need to address, I'm going to address the restitution. I'll go over court costs. Mr. Slepsky, you are ordered to pay the court costs in this case. If you fail to pay any financial penalty or costs, the court may order you to perform up to 40 hours a month of community service until the court is satisfied that you're in compliance with an approved payment schedule. If you perform community service on this basis, your financial penalty or costs will be reduced to the extent of the federal minimum wage. The court isn't ordering any payment plan or community service at this time, but renders judgment against you for the costs for which execution may issue. I will limit the amount taken from your inmate account to $5 a month while you're incarcerated, however, to be applied toward costs. All right, as far as the issue of restitution, I am going to defer ruling on the restitution. I'm going to give each side, is 14 days acceptable?
Yeah, sure.
Okay, give each side 14 days to compile the information necessary, and if an additional restitution hearing is requested, you can do that within the next 14 days, and we'll take a little bit of a closer look at the restitution. All right, I believe that covers what I needed to cover. Mr. Flay, is anything else that the court needs to address at this time? Oh, well, I guess there is something else that I'm aware the court needs to address, and that is the issue of the sentence and when it will begin. So as far as that's concerned, either attorney wish to be heard at this time?
Your Honor, I would ask the court for a stay of the execution of the sentence under Revised Code 295309. I know that the court is aware, and through our pretrial negotiations and conversations, that the case was going to go up on appeal, and we, I think in anticipation of that, have spoken with the court regarding a stay specifically, and so we are asking the court to stay execution of the sentence under the Revised Code.
All right, thank you. Mr. Flay.
Thank you, Your Honor. As discussed previously with the court, the state does oppose that request. Again, the state does understand that an appeal is forthcoming, and that a stay will be requested. The state's not going to oppose that stay while this matter is being litigated. However, for purposes of today's hearing, the defendant has been sentenced. He has received a mandatory prison sentence. He's under a mandatory prison sentence. And as we discussed with the court earlier, there's some potential issues there. So I think that this would motivate the paperwork to be done in a timely manner, and the defendant would be in custody. It might only be a matter of days, but he would at least be in custody while procedurally things are done correctly, like the judgment entry being filed, an appeal being filed, notice of appeal being filed, and the stay actually being filed and docketed. Thank you.
All right, thank you. Go ahead, Ms. Stevens.
Can we approach briefly? Okay.
Dan DeRosa with 19 News here. The attorneys are going to have a little sidebar with the judge. What they're debating here is whether or not Mr. Slepsky has to go to prison right away. There is going to be an appeal, much like any case. The defendant has the right to appeal. There is that sort of strange circumstance. The amount of weed that was in his system is being debated by the Ohio Supreme Court, I believe either this week or next week. So there is a question about that level of marijuana that was in his system. But we also heard the state say that Slepsky had just come from a bar, and that is a stop sign right by his home that he completely blew through. That's a stop sign he's aware of, he knows about it, he lives by that stop sign. It was a two-way stop sign, and he failed to yield to an ambulance that had its lights on. So that part of this is not up for debate. So to ask that he doesn't have to go to prison right away so that they can appeal this, well, I'm not sure how the judge is going to view that. The state said that they do not support that idea of letting him be out. I did notice Mr. Slepsky took out his cell phone. He's already texting or whatever on his phone. If I were Mr. Slepsky, I would not have my cell phone out at my own sentencing until everything was said and done. The judge may see that and not think that that's a great idea, but we'll wait and see. But again, this idea that he wants to stay out of prison during this, we'll see what the judge has to say.
There will be a final appealable order with the restitution still outstanding. So what I am going to do is I'm going to modify my decision as it applies to the restitution. I'm not going to order restitution in this case. Certainly there's still the ability for a civil case for the organization seeking compensation. So that would make this court's order a final appealable order. All right. Anything else we need to address, counsel?
No, thank you, Your Honor.
Anything else? All right, we're adjourned. Thank you. So Mr. Slepsky will be taken into custody at this time, and we will address any stay at the future date.
Thank you.
Can I ask that everyone remain seated until the deputies exit the courtroom?
So a little confusing there, but Mr. Slepsky will be taken into custody, will be at least in the county jail until some of the matters are fixed on this. He did win a little bit there in that instead of saying, you know, because restitution hasn't been decided, there are some questions about someone in one of their letters may have said, oh, I'm out this amount of money because of the accident, what has happened. Well, that's not proven. That was just a statement. The defense said, you know, there needs to be documentation on that. So the judge said, okay, we'll decide restitution at a later date. Well, what that does is that delays this sentencing. And so the judge said, okay, here's what we'll do. No restitution at this point so that he can be remanded. Will sit in jail as the appeal is taken care of. So it got a little bit confusing there. The judge trying to clear things up. Bottom line, he gets 4 years. You heard the judge read quite a bit of quite a few years there. Count one was the vehicular homicide. He gets 4 years for that. Then count two, the aggravated vehicular assault. He also got 4 years for that. And then count three, he got 3 years for that charge as well. So you add those up, it looks like he should have gotten 8 to 11 years. But because the judge is running them concurrently, meaning at the same time, he gets just 4 years. The judge could have decided to run them consecutively, meaning he serves 4 years, then he serves the next 4 years, then he serves the 3 years. But the judge cut him a little bit of a deal there, a little bit of slack, and gave him the sentences concurrently, so they will all start at the same time when he reports to prison. That's going to wrap this up. Again, just a devastating set of circumstances for the patient who died in the back of that ambulance when Slepsky ran a stop sign and slammed into the ambulance. It rolled, it flipped. The EMS, the paramedic worker in the back was seriously hurt, and the driver was hurt as well, and he gets 4 years in prison. If we have any other breaking news, it'll be right here on our digital platforms. Our 11 o'clock news just underway on CW43, and then our noon news coming up on Channel 19. Until then, I'm Dan DeRosa with 19 News. Have a good afternoon.
19 News is everywhere. Download our CTV apps and follow us on social media @Cleveland 19 News.